The gavel doesn't just fall, it shatters dreams. Judge Thornton Harrington's voice cuts through courtroom 402 like a blade through silk, each word dripping with the kind of condescension that turns justice into theater. Miss Blackwell, did you perhaps confuse this federal courthouse with traffic court? Because your legal arguments are about as sophisticated as a parking ticket dispute. His laughter echoes off the mahogany walls, a sound that's become as familiar to this Philadelphia courthouse as the morning security alarms. For 18 years, Harrington has ruled from that bench like a monarch in robes, his silver hair perfectly styled, his gray eyes cold as winter steel. He is power incarnate, justice corrupted, the law twisted into whatever shape serves his purposes. At the defense table sits Savannah Blackwell, and to every observer in this packed courtroom, she looks exactly like what Harrington claims she is. An overworked public defender drowning in a case too big for her modest qualifications. Her navy suit is pressed but clearly off the rack. Her briefcase shows the wear of countless courthouse visits. Her black pumps are practical, not expensive. Everything about her screams struggling attorney taking on the federal system with nothing but hope and determination. But there's something in her posture that doesn't match the stereotype. Her spine is military straight. Her dark eyes never waver, never seek approval, never beg for mercy. When she takes notes, she uses a Mont Blanc pen that costs more than most public defenders make in a week. A detail that's escaped everyone except the man currently humiliating her from his throne. The case file before her reads, United States versus Meridian Construction, and on paper it should be routine. Federal tax evasion 18 counts. Her client, Rebecca Sterling, is a bookkeeper who allegedly discovered her company was running a massive money laundering operation through shell corporations. Simple whistleblower protection, basic federal procedure. Except nothing about this case has been simple. For 3 days, every piece of evidence Savannah has presented has been deemed inadmissible. Every objection she's raised has been overruled with theatrical flourish. The prosecutor, a slimy career climber named Harrison Crawford, smirks from his table like a man who's already counting his conviction statistics. The gallery is packed with reporters, fellow attorneys, and court staff, all watching what appears to be a masterclass in how the system crushes the unprepared. If you've ever been underestimated because of how you looked, you're going to love what happens to this arrogant judge. Hit that like button because justice is about to be served ice cold. Your Honor, Defense Motion 23C clearly establishes. Savannah's voice is steady, professional, betraying none of the supposed nervousness her appearance suggests. Harrington cuts her off with a wave that might as well be swatting a fly. Miss Blackwell, I've read your motion. Your understanding of federal procedure is, how should I put this delicately? Remedial. Motion denied. The word remedial hangs in the air like poison gas. Court reporter Ruby Winchester's fingers freeze over her keyboard for just a moment. The insult so blatant that even she, veteran of 2 decades in this courthouse, feels secondhand embarrassment. The gallery stirs uncomfortably. This isn't judicial authority. It's public humiliation. But Savannah Blackwell doesn't flinch, doesn't stammer an apology, doesn't shrink into herself the way most attorneys would after such a public dressing down. Instead, she reaches into her briefcase and pulls out that expensive pen, making a precise notation in a leather portfolio that looks far too sophisticated for her supposed station. The portfolio is burgundy leather, hand-stitched, the kind that costs more than her entire outfit. Harrington notices it. His eyes linger on that portfolio just a beat too long, and something flickers across his face. Not quite concern, but the first shadow of unease. Miss Blackwell, he continues, his voice taking on the tone of a professor addressing a particularly slow student. I'm genuinely curious. Where exactly did you receive your legal education? Because your grasp of constitutional law seems, shall we say, limited. The question hangs in the air like a challenge. In the gallery, a few lawyers lean forward. This is getting personal now, moving beyond professional disagreement into something uglier. Harrington is fishing, trying to establish her credentials so he can tear them down publicly. Yale Law School, Your Honor. Her response is calm, matter of fact, without a trace of defensiveness. Order of the coif. Order of the coif. Top 10% of the class. The gallery knows what that means. These aren't the credentials of someone who doesn't understand constitutional law. But Harrington's smile only widens, becoming something predatory. Ah yes, diversity admissions. Wonderful program. Though it does sometimes lead to situations like this. The silence that follows is deafening. Even Prosecutor Crawford shifts uncomfortably in his chair. Ruby Winchester's fingers have completely stopped moving. This isn't just professional criticism anymore. It's something darker, more personal, laced with implications that make everyone in the room acutely aware of the color of Savannah's skin and the assumptions that come with it. But again, Savannah's expression doesn't change. She reaches into that expensive portfolio and pulls out what appears to be a federal case citation manual, not standard equipment for a typical public defender. The manual is thick, well-worn, filled with bookmarks and handwritten notes. This is the tool of someone who knows federal law intimately, not someone learning it on the fly. When most attorneys get humiliated the way Savannah just has, they stammer apologies. They back down. They try to placate the judge who controls their professional fate. Savannah Blackwell does something completely different. She stands. Not hurriedly, not defensively, but with the kind of military precision that suggests training most lawyers never receive. Her movement is fluid, controlled, commanding attention without demanding it. Every eye in the courtroom fixes on her as she adjusts her blazer with the careful attention of someone used to being watched, evaluated, judged. "Your Honor," she begins, her voice carrying a new weight, a different authority. Title 18, Section 242 of the United States Criminal Code specifically addresses the willful deprivation of constitutional rights under color of law. The penalty for violation is imprisonment up to 1 year, or if bodily injury results up to 10 years. Harrington blinks. Whatever he expected her to say, it wasn't a word-perfect recitation of federal criminal statutes. "I'm sorry, what does that have to do with—" "I'm simply noting the statute for the record, Your Honor, for future reference." The way she says future reference sends a chill through the room. This isn't a legal argument. It isn't even a threat in any conventional sense. It's something else entirely. A warning, perhaps, or maybe just information being carefully logged for reasons no one in this room quite understands. But Judge Harrington suddenly feels very uncomfortable on his throne. During the lunch recess, the courthouse empties in the usual pattern. Lawyers heading to nearby cafes, court staff grabbing sandwiches from the basement vending machines, reporters clustering in the hallway to compare notes on the morning's drama. It's the kind of institutional rhythm that's played out in federal courthouses across the country for decades, as predictable as the sunrise. Ruby Winchester doesn't usually pay attention to what attorneys do during breaks. After 20 years as a court reporter, she's seen every possible variety of legal meltdown, victory celebration, and nervous breakdown. But something about Savannah Blackwell keeps drawing her attention. Some quality that doesn't quite fit the role she appears to be playing. Through the tall windows that line the courthouse corridor, Ruby watches as Savannah steps outside for what appears to be a phone call. Nothing unusual about that. Every lawyer in America lives on their phone, fielding calls from clients, colleagues, family members trying to understand why legal proceedings take forever and cost fortunes. But this call is different. Savannah turns away from the building's main entrance, walking toward the less populated side street where foot traffic is minimal. She keeps her voice low, but the acoustics of the stone corridor carry sound in strange ways, and Ruby catches fragments through the partially open window. "Agent Mitchell, surveillance is proceeding as expected. The target is exhibiting all predicted behaviors. We should have sufficient evidence by tomorrow's session." Ruby's fingers, trained by decades to record every word with mechanical precision, freeze completely. Target? Surveillance? What public defender talks about targets and surveillance? And who is Agent Mitchell? Ruby has worked federal court long enough to know that public defenders don't typically coordinate with federal agents. If anything, they're usually on opposite sides of cases. The call ends quickly, and Savannah returns to the courthouse with the same composed demeanor she's maintained all morning. But now Ruby can't shake the feeling that she's watching a performance rather than authentic legal advocacy. There's something too controlled about Savannah's reactions, too prepared, as if she's following a script written long before this trial began. Something is seriously wrong with this picture. Why does this overwhelmed public defender know federal criminal codes by heart? Keep watching. This woman is about to blow everyone's mind. When court reconvenes after lunch, the afternoon light streaming through the tall windows gives courtroom 402 an almost theatrical quality. Harrington returns to his bench with renewed confidence, apparently convinced that his morning humiliation of Savannah has re-established the proper order of things. Crawford shuffles through his files with the satisfaction of a prosecutor who knows the judge is on his side. The gallery settles in for what they expect will be more of the same, a systematic dismantling of an overmatched defense attorney. But Savannah has brought new documents. She presents them with the same calm professionalism she's shown all morning, but the papers themselves are extraordinary. Internal corporate documents that should be nearly impossible for a public defender to obtain. Wire transfer records from offshore accounts. Shell company and corporation papers filed in Delaware and Nevada. Each document is properly authenticated, properly introduced, backed by federal evidentiary rules that make them unassailable. Crawford objects, of course. "Your Honor, Defense Exhibit 17B was clearly obtained without proper warrant procedures. Savannah doesn't even glance at her notes before responding. United States v. Leon, 1984. Good faith exception to the exclusionary rule. The evidence was obtained under Federal Rule of Criminal Procedure 41E2B, Emergency Circumstances Exception, later ratified by warrant under the Inevitable Discovery Doctrine established in Nix v. Williams, 1984. The response is immediate, precise, delivered without hesitation or consultation with any reference materials. These aren't the fumbling citations of someone learning federal procedure on the fly. This is the fluent recitation of someone who knows the federal rules of criminal procedure, the way most people know the alphabet. Harrington's face has gone pale beneath his perfectly styled silver hair. How could you possibly know? Know what, Your Honor? The law? The question hangs in the air with devastating simplicity. In 3 words, Savannah has turned Harrington's entire morning of condescension back on itself. Of course she knows the law. That's supposed to be the bare minimum requirement for practicing in federal court. The real question, the one that's beginning to dawn on everyone in the room, is why Harrington seemed surprised by her competence. But Savannah isn't finished. The documents she's presenting aren't random exhibits plucked from discovery. They form a pattern, a systematic dissection of what appears to be a massive criminal conspiracy. Each bank record connects to shell companies. Each shell company traces back to Meridian Construction. And the money trails don't just show tax evasion, they show something much larger. Your Honor, I'd like to present Defense Exhibit 31C, bank records showing regular monthly transfers from Meridian subsidiaries to offshore accounts linked to public officials in the Eastern District of Pennsylvania. The words public officials hit the courtroom like a physical force. This isn't just a tax case anymore. Savannah is alleging corruption at the highest levels of local government. Crawford half rises from his chair, his face flushed with alarm. That's completely irrelevant to this tax case. But Harrington's reaction is even more telling. His voice cracks slightly as he speaks, betraying the first real fear he's shown all day. That's completely irrelevant to this tax case. Savannah looks directly at him, her dark eyes holding his gray ones with uncomfortable intensity. Is it, Your Honor? Because these records show payments totaling $340,000 to account number 7749RB3021. Would Your Honor like me to read the name on that account? The silence that follows is absolute. Harrington has gone white as his own judicial robes. Crawford is shuffling papers frantically, apparently looking for some procedural lifeline to throw into this rapidly deteriorating situation. And in the gallery, Ruby Winchester finally realizes why Savannah Blackwell looked familiar. 6 weeks ago, Ruby had delivered documents to the FBI field office downtown, a routine transfer of court records that happens occasionally when federal cases intersect with ongoing investigations. She'd been directed to a secure conference room on the 3rd floor, where she'd glimpsed a woman in an expensive suit conferring with federal agents. The woman had been commanding the room with quiet authority, speaking in technical terms about federal statutes and investigative procedures. She'd moved like someone accustomed to power, gestured like someone used to being listened to, carried herself like someone who'd never doubted her right to be in any room she entered. The nameplate on the conference room door had read, Special Prosecutor Blackwell, DOJ Public Integrity Section, Department of Justice, Public Integrity Section, the federal unit that investigates corruption in government, the people who bring down dirty politicians and crooked judges and anyone else who sells their oath for personal gain. Ruby stares at the defense table, her trained memory putting together details she'd missed before. The expensive pen that doesn't match the modest suit. The leather portfolio that costs more than most attorneys make in a month. The immediate, flawless knowledge of federal criminal procedure. The phone call about surveillance and targets. Holy cow, she whispers to herself, so quietly that even her sensitive court reporting equipment doesn't pick it up. She's not defending the whistleblower. She is the investigation. But if Ruby has figured it out, she's apparently the only one. Harrington is still struggling to regain control of his courtroom, his face cycling through expressions of confusion, anger, and something that might be panic. The morning's confident condescension has evaporated, replaced by the defensive posture of a man who suddenly finds himself on unfamiliar ground. Miss Blackwell, he says, his voice carrying a warning tone that sounds more desperate than authoritative. I'm warning you. You are walking a very dangerous line here. Very dangerous indeed. Is Your Honor threatening an officer of the court? The question is delivered with perfect professional courtesy, but its implications are devastating. If a federal judge is threatening an attorney in open court, It's grounds for misconduct charges. If he's doing it to cover up evidence of his own corruption, it's grounds for criminal charges. Savannah has just cornered him with his own words, using his attempt at intimidation as evidence of consciousness of guilt. I'm protecting this courtroom from a fishing expedition by an incompetent. Incompetent! Savannah stands again, this time with even more deliberate care. Every movement is measured, controlled, designed to command attention. She's no longer playing defense. This is the posture of someone going on the attack. Your Honor, I graduated summa cum laude from Yale Law School. I clerked for Justice Ginsburg on the Supreme Court. I've successfully prosecuted 43 federal corruption cases with a 100% conviction rate. Which of those accomplishments suggests incompetence to you? The courtroom gasps audibly. These aren't the credentials of a struggling public defender. They're the resume of someone at the very top of the legal profession. Supreme Court clerks don't become public defenders. Federal prosecutors with perfect conviction records don't handle routine tax cases, unless they're hunting bigger prey. The shift in the room is palpable. Reporters in the gallery are frantically typing notes into their phones. The court staff is exchanging meaningful glances. Even Crawford has stopped pretending to work on his files, instead staring at Savannah with the expression of a man who's just realized he's been swimming with sharks. But Harrington isn't ready to surrender. 18 years on the bench have taught him that judicial authority can overcome almost any challenge, that the black robes carry weight that few attorneys are willing to challenge directly. He leans forward, attempting to use his physical position on the raised bench to reassert dominance. Miss Blackwell, I don't care if you clerked for the entire Supreme Court. You will not turn my courtroom into a circus with these wild accusations and conspiracy theories. You will confine yourself to the evidence relevant to the charges against your client, or I will hold you in contempt. It's a tactical mistake. By threatening contempt, Harrington has revealed just how rattled he's become. Confident judges don't need to threaten attorneys who are supposedly incompetent. They simply overrule their objections and move on. The threat exposes his fear, confirms that Savannah has touched something he desperately wants to keep hidden. As Savannah reaches for another document from her briefcase, the leather case tips slightly, spilling papers across the polished marble floor. She drops to one knee to collect them, and in that moment, Ruby Winchester sees something that makes her blood freeze. A gold federal prosecutor's badge, gleaming under the courtroom's fluorescent lights. And beneath it, an FBI identification card with Savannah's photograph and the title, Special Agent, Public Integrity Section, Federal Bureau of Investigation, Public Integrity Section. Not just a prosecutor, an agent with the power to investigate, arrest, and bring down corrupt officials at every level of government. Ruby's whispered, "She's FBI," is barely audible, but Crawford hears it. His confident smirk evaporates instantly, replaced by the pale terror of a man who's just realized he's been working with a corrupt judge, while an undercover federal agent documented every conversation, every illegal agreement, every moment when they chose personal gain over justice. Savannah's phone buzzes. The sound is soft, barely noticeable in the larger courtroom, but it cuts through the tension like a signal flare. She glances at the display, then looks up at Judge Harrington with an expression that's somehow both apologetic and predatory. "Your Honor, I need to take this call. It's urgent." She steps just outside the courtroom doors but leaves them slightly ajar. Her voice carries back into the courtroom with crystal clarity, and everyone inside realizes simultaneously that she wants them to hear this conversation. "Agent Mitchell, yes, we have enough. Execute the warrants, all of them. I'll keep the targets in place until your team arrives." The words hit the courtroom like individual hammer blows. Warrants, targets, team. This isn't the vocabulary of legal defense. It's the language of law enforcement operations, of coordinated federal raids, of the moment when months or years of investigation suddenly become arrests and indictments. Harrington turns to Crawford with panic barely concealed behind his judicial mask. "Targets? What targets? What the hell is happening here?" But Crawford can't answer. He's staring at his own hands, probably calculating how many laws he's broken, how many conversations he's had that might have been recorded, how many years in federal prison he's looking at if Savannah really is what she appears to be. When Savannah returns to the courtroom, she's no longer hiding. The transformation is subtle but complete. She walks with the confidence of a federal agent rather than the uncertainty of an overwhelmed public defender. Her posture has shifted from defensive to commanding. Her expression has moved from hopeful to predatory. "Your Honor, I move to present Defense Exhibit 47A, federal wiretap recordings of conversations between Your Honor, Prosecutor Crawford, and CEO Maxwell Meridian. discussing specific case outcomes in exchange for financial compensation. The words hang in the air like an atomic bomb with a slowly ticking timer. Federal wiretaps, recorded conversations, evidence of bribery and conspiracy at the highest levels of the local justice system. Harrington explodes from his chair. You have no authority. You're a public defender. You can't present federal evidence in state court. Savannah reaches into her jacket pocket and pulls out her federal badge, placing it carefully on the defense table where the courtroom's overhead lights make the Department of Justice seal gleam like a beacon. The gold badge sits there like a bomb. Impossible to ignore. Impossible to explain away. Actually, Your Honor, I can. The badge settles into silence that feels dense enough to cut with a knife. Every person in the courtroom is staring at it, understanding flooding their faces as the last pieces of an 18-month puzzle snap into place. The reporters realize they're not just covering a routine tax trial, they're witnessing the culmination of a massive federal corruption investigation. The court staff understands why certain files have been sealed, why certain procedures have been different, why federal agents have been more visible around the courthouse in recent weeks. Let me properly introduce myself to the court. Savannah's voice carries the authority of someone who's spent months hiding her true identity and is finally free to drop the mask. Special Federal Prosecutor Savannah Blackwell, Department of Justice Public Integrity Section assigned by the Attorney General to investigate judicial corruption in the Eastern District of Pennsylvania. You could hear a pin drop in the marble-floored courtroom. The magnitude of what's happening is sinking in with devastating clarity. This isn't just a tax case gone wrong. It's the climax of a federal sting operation that's been 18 months in the making. Every conversation, every ruling, every moment of judicial bias has been observed, recorded, analyzed by federal agents building a case that could send powerful people to prison for decades. Harrington's face cycles through denial, rage, fear, and back to rage. This is entrapment. This is illegal. You can't conduct federal investigations under false pretenses. United States v. Russell, 1973. Savannah doesn't need to consult any notes or casebooks. This is the law she lives and breathes, the authority under which she's been operating for months. Federal agents may use deception during investigations provided they don't induce criminal behavior that would not otherwise occur. Your Honor, we didn't make you take bribes. We simply gave you the opportunity to refuse them. The legal analysis is devastating in its simplicity. Every corrupt decision Harrington made, he made voluntarily. Every illegal payment he accepted, he chose to accept. The federal investigation didn't create the corruption. It simply documented what was already there. As if summoned by her words, the courtroom's heavy double doors swing open with a sound like thunder. Special Agent Marcus Mitchell walks through those doors with 5 other federal agents, all wearing the unmistakable authority of the FBI. They move with military precision, spreading out to cover the room's exits, their presence transforming the space from a courtroom into a crime scene. Agent Mitchell is tall, unsmiling, carrying himself with the confidence of someone who's done this before. He stops directly in front of the bench, forcing Harrington to look down at him, a reversal of the usual power dynamic that's as symbolic as it is practical. Special Prosecutor Blackwell, we have the warrants. Thank you, Agent Mitchell. Perfect timing. The exchange is professional, routine, the kind of coordination that happens when federal agents have been planning an operation for months. But to everyone else in the courtroom, it's like watching a magic trick where the illusion suddenly becomes reality. Harrington stands behind his bench, gripping the mahogany surface as if it might anchor him to a world that's suddenly shifting beneath his feet. This is my courtroom. You have no jurisdiction here. Agent Mitchell's response is delivered with the patient tone of someone explaining federal law to a civilian. Actually, Your Honor, federal corruption charges supersede state jurisdiction under Title 18, Section 1961. Judge Thornton Harrington, you are under arrest for conspiracy, bribery, money laundering, and civil rights violations under color of law. For 18 years, Harrington has sent people to prison from that bench. He's pronounced sentences that destroyed lives, separated families, condemned defendants to decades behind bars. Now, as Agent Mitchell begins reading him his Miranda rights, he's learning what it feels like to be on the receiving end of the justice system he's corrupted for personal gain. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. The Miranda warning echoes through the courtroom with institutional authority. These are the same words Harrington has heard thousands of times as defendants were processed through his court, but hearing them directed at himself transforms them into something alien and terrifying. Harrington turns to Savannah, his voice breaking with a mixture of rage and disbelief. You deceived everyone. You lied to this court." Savannah adjusts her suit jacket with the careful attention of someone who's about to deliver a lesson in the difference between deception and investigation. "No, Your Honor, I told you exactly who I was. You just assumed I was something less." The response cuts to the heart of everything that's happened over the past 3 days. Savannah never lied about her credentials. Yale Law School, Order of the Coif, Supreme Court clerkship. She never claimed to be incompetent or unprepared. Harrington simply saw a black woman in a modest suit and assumed she couldn't possibly be a threat to his authority. His assumptions became his downfall, but the revelations aren't over. Agent Mitchell's team moves through the courtroom with practiced efficiency, and their next target is the prosecutor's table. "Harrison Crawford, you're also under arrest. Conspiracy to obstruct justice, accepting bribes, and violating your oath as a prosecutor." Crawford tries to run. He actually tries to run, pushing back from his chair and heading for the side exit as if he can somehow escape from a room surrounded by federal agents. It's a pathetic gesture, the desperate flight of someone who's finally understanding the magnitude of his situation. Agent Mitchell's team stops him before he reaches the door, their movements economical and professional. Crawford collapses into tears, the facade of prosecutorial authority crumbling completely. "I was following orders. Harrington made me do it. I have a family." It's the classic defense of every corrupt official who's ever been caught. Blame someone else, claim coercion, appeal to sympathy, but Savannah's response is as final as a judge's gavel. "Mr. Crawford, you had choices. You chose to sell justice to the highest bidder." The moral clarity of her statement hangs in the air like a judgment that can't be appealed. Every person in that courtroom, every reporter, every court staff member, every client understands that this moment represents something larger than just another corruption case. This is about the fundamental promise that justice is blind, that the law applies equally to everyone, that no one is above accountability. As federal marshals place Harrington and Crawford in handcuffs, the symbolism is impossible to miss. These men who've spent their careers wielding the power of the justice system are now subject to it in the most fundamental way possible. The handcuffs clicking shut sound like the closing of a chapter, the end of a story that's been 18 months in the writing. Savannah opens her expensive leather portfolio, the one everyone noticed but no one understood until now. Inside are 18 months of meticulous federal investigation, bank records documenting illegal payments, wire recordings capturing corrupt conversations, photographs showing secret meetings, and testimony from 12 other judges who've already been arrested in coordinated raids across 4 states. The scope is breathtaking. This isn't just about one corrupt judge in Philadelphia. It's about a network of corruption that reaches across multiple states involving dozens of officials who thought their positions made them untouchable. "Your Honor, excuse me, Mr. Harrington, this investigation began when the Justice Department noticed statistical anomalies in case outcomes in your courtroom. Defendants represented by certain politically connected attorneys had conviction rates 73% lower than the district average. The statistical analysis reveals the sophisticated nature of the federal investigation. This wasn't a random inquiry or a response to a single complaint. It was a systematic analysis of court data that identified patterns suggesting corruption. When federal investigators see numbers that don't make sense, they dig deeper. And what they found in Harrington's courtroom was evidence of a justice system that had been turned into a marketplace. Speaking of corruption and cover-ups, let me tell you about Secure Vault Pro, the encrypted document storage that helps whistleblowers and investigators protect sensitive evidence from tampering. Use code JUSTICE20 for 20% off your first year and keep your truth safe from those who want to bury it. But the biggest revelation is yet to come. Savannah produces a final set of documents, and these reveal that the conspiracy reaches far beyond anything the courtroom has imagined. "Agent Mitchell, do we have confirmation on Operation Clean Slate?" "Yes, ma'am. Teams in Los Angeles, Chicago, Denver, and New York executed simultaneous warrants this morning. We've arrested 11 federal judges, 19 prosecutors, and 34 corporate executives. The entire network is neutralized." The numbers hit the courtroom like individual shockwaves. 11 judges, 19 prosecutors, 34 executives. This isn't just about local corruption. It's about a nationwide criminal enterprise that's been buying and selling justice like any other commodity. The scope reveals the true sophistication of what Savannah has been part of. While everyone in this courtroom thought they were watching a simple tax case, She's been the Philadelphia component of a massive federal operation spanning multiple states and involving dozens of corrupt officials. The morning's humiliation, the afternoon's revelations, Harrington's arrest, all of it has been carefully coordinated to happen simultaneously, with similar scenes playing out in federal courthouses across the country. Maxwell Meridian, the CEO at the center of it all, wasn't just bribing local officials. He was running a nationwide operation, buying verdicts in federal courts from coast to coast, turning the American justice system into a subsidiary of his construction empire. Harrington and Crawford were just regional managers in a criminal organization that reached into the highest levels of the federal judiciary. As the reality of the situation settles over the courtroom, the personal cost becomes clear. Harrington, still in handcuffs, looks at Savannah with the expression of a man who's just realized how completely he's been outplayed. All those years, all those cases, I decided, you were watching, recording everything, every conversation, every illegal payment, every time you perverted justice for money. Savannah's response carries the weight of 18 months of careful documentation. Rebecca Sterling, my client, wasn't just a whistleblower, Mr. Harrington. She was an undercover federal accountant who volunteered to gather evidence against you. The revelation hits like a final hammer blow. Rebecca Sterling, the quiet bookkeeper who sat silently through days of testimony, stands up and removes a small recording device from her jacket lapel. Her modest appearance has been as carefully crafted as Savannah's, her role as carefully planned. Special Agent Rebecca Sterling, Financial Crimes Division. It's been an education watching you work, Your Honor. 2 federal agents, both undercover, both documenting every moment of corruption while appearing to be ordinary participants in the justice system. The elegance of the operation is matched only by its effectiveness. Harrington and Crawford have been performing their corruption in front of the very people tasked with bringing them down. Ruby Winchester, who's spent 20 years watching Harrington's courtroom, finds herself openly crying. The tears aren't just for the specific injustices she's witnessed, but for the broader realization of how completely the system has been corrupted. All those innocent people he sent to prison, all those families he destroyed for money. Savannah's response carries the promise of something approaching redemption. Every case will be reviewed, Ruby. Every single one. The Justice Department is already preparing appeals for an estimated 400 wrongful convictions spanning Mr. Harrington's tenure. 400 wrongful convictions. 400 families destroyed by decisions made not in pursuit of justice, but in service of personal profit. The number represents years of systematic corruption, a perversion of the justice system so complete that it turned courtrooms into criminal enterprises. As federal marshals lead Harrington away in handcuffs, he makes one final attempt to justify what he's done, to find some moral ground that might explain 18 years of corruption. You think this changes anything? You think you've won? The system is bigger than one judge. Savannah looks him straight in the eye, her response carrying the moral authority of someone who's spent months witnessing the corruption of everything she's sworn to protect. You're absolutely right about one thing, Mr. Harrington. The system is bigger than any one person. That's exactly why it's going to survive your betrayal of it. This is how justice works when good people refuse to give up. If this story of accountability and courage gives you hope for our system, hit that like button and share this with everyone who needs to see that truth always wins. The courtroom empties slowly, as if the people inside need time to process what they've witnessed. Reporters rush to file stories that will dominate news cycles for weeks. Court staff begins the process of securing evidence and preparing for the administrative chaos that follows the arrest of a sitting judge. Federal agents coordinate with local authorities to ensure the smooth transfer of ongoing cases to judges who aren't currently in handcuffs. But for Savannah Blackwell, this is just another day at the office. As she packs her real files into her expensive portfolio, no longer needing to hide the quality of her equipment or the sophistication of her legal materials, she moves with the satisfaction of someone who's just completed a job well done. The transformation is complete now. The modest public defender who walked into this courtroom 3 days ago was a carefully constructed fiction. The woman packing her briefcase is Special Federal Prosecutor Savannah Blackwell, Department of Justice Public Integrity Section, one of the most effective corruption investigators in federal law enforcement. She spent 18 months living this fiction, becoming Harrington's perfect victim. A black woman he could humiliate without consequences, an attorney he could dismiss without fear, a public defender whose competence he would never suspect because his own prejudices made it impossible for him to see her clearly. His blindness became his weakness. His assumptions became his confession. His need to prove his superiority led him to perform his corruption in front of the very person tasked with documenting it for federal prosecutors. As Savannah walks through the courthouse corridors that have been her stage for 3 days, she passes the bench where she sat during lunch recesses, the phone booth where she made calls to Agent Mitchell, the windows where Ruby Winchester watched her coordinate with federal law enforcement. Every location holds memories of a performance that required her to be simultaneously invisible and omnipresent, gathering evidence while appearing helpless, building a federal case while pretending to struggle with basic legal concepts. The performance is over now. The mask has been removed. The truth has been revealed. And justice, real justice, federal justice, the kind that can't be bought or corrupted or perverted for personal gain, has finally arrived in courtroom 402. But this is only the beginning. In Houston, in Denver, in Los Angeles, and New York, similar scenes are playing out as the full scope of Operation Clean Slate becomes visible. Corrupt judges are being arrested. Dirty prosecutors are being indicted. Corporate executives who thought they could buy the American justice system are learning that some things, some fundamental principles, are not for sale. Savannah Blackwell has work to do. Part 2. Climax through resolution and closure, 55 to 100%. The aftermath of Judge Harrington's arrest sends shockwaves through Philadelphia's legal community that ripple outward like seismic waves from an epicenter. Within hours, the story dominates every major news network, social media platform, and legal publication in the country. Cable news anchors struggle to convey the magnitude of what's happened. A sitting federal judge, arrested in open court by FBI agents. His 18-year reign of corruption exposed by an undercover federal prosecutor who spent months pretending to be exactly the kind of attorney he routinely humiliated. But for Savannah Blackwell, the media circus represents only the beginning of a much larger reckoning. 3 blocks from the courthouse, in a secure FBI field office that's been the nerve center of Operation Clean Slate for 18 months, banks of monitors display real-time feeds from federal courthouses across 4 states. Los Angeles, Chicago, Denver, New York. In each city, similar scenes are playing out as the coordinated raids that began in Philadelphia reach their targets. Agent Mitchell coordinates the operations from a command center that looks more like mission control than a traditional law enforcement facility. Dozens of agents monitor communications, track arrest warrants being executed, and manage the complex logistics of simultaneously dismantling a criminal network that reaches into the highest levels of the federal judiciary. Status report, Mitchell announces to the room, his voice carrying the authority of someone who's been planning this moment for over a year. The responses come in rapid succession from field offices across the country. Los Angeles, federal judge Patricia Hammond in custody, 3 associates arrested, evidence secured. Chicago, Judge Robert Williamson arrested at his country club, financial records seized from his residence and chambers. Denver, Judge Michael Foster taken into custody during a charity dinner. His co-conspirators are being processed now. New York, Judge Amanda Rowe arrested at the federal courthouse. Her aide and 2 attorneys also in custody. Each report represents months of careful investigation, surveillance, and evidence gathering. But the scope extends far beyond corrupt judges. Corporate executives, political operatives, and mid-level bureaucrats who facilitated the corruption network are being arrested in coordinated sweeps that span time zones and jurisdictions. Maxwell Meridian, the construction CEO who orchestrated much of the nationwide bribery scheme, was arrested at his private golf club in suburban Philadelphia at precisely 10:30 a.m. The same moment Agent Mitchell was reading Miranda rights to Judge Harrington. Federal agents found him on the 9th hole, attempting to destroy documents with a cigarette lighter while his golf partners watched in stunned silence. The timing wasn't coincidental. Operation Clean Slate has been planned with military precision, each arrest carefully coordinated to prevent communication between co-conspirators, to preserve evidence, and to maximize the psychological impact of seeing an entire criminal network dismantled simultaneously. Savannah stands before a wall of monitors displaying mugshots, financial records, and organizational charts that map the connections between corrupt officials and the corporate interests that bought them. After 18 months of living undercover, of enduring daily humiliation to gather evidence, of pretending to be weak while building a federal case that will send powerful people to prison for decades, she finally sees the full scope of what she's helped accomplish. 11 federal judges, Agent Mitchell reports, updating the tally as new arrests are confirmed. 19 prosecutors across 6 states, 34 corporate executives and their associates. Total financial recovery expected to exceed $200 million in seized assets, unpaid taxes, and criminal fines. The numbers represent more than successful law enforcement. They represent the restoration of faith in a system that millions of Americans depend on for justice. Every corrupt judge removed from the bench means hundreds of future cases will be decided on their merits rather than on who paid whom. Every dirty prosecutor arrested means defendants will face fair proceedings rather than predetermined outcomes. But the human cost of the corruption runs deeper than statistics can capture. Ruby Winchester, who spent 20 years watching Harrington's courtroom without understanding the full extent of his corruption, has volunteered to help federal investigators identify cases that may require review. Her institutional memory, combined with court records and the evidence gathered during Operation Clean Slate, will be crucial in determining which convictions were the result of legitimate judicial proceedings and which were purchased by corporate interests. 412 cases requiring immediate review. Ruby reports to the federal investigators who've set up a temporary processing center in the courthouse's administrative wing. That's just from Judge Harrington's docket over the past 5 years. If the patterns hold for his entire tenure, we're looking at potentially 800 to 1,000 wrongful convictions. Each number represents a life disrupted by corruption. Defendants who received harsher sentences because they couldn't afford the right attorneys. Families separated because justice was for sale. Communities damaged by a system that responded to money rather than evidence. The review process will take months, possibly years. Federal investigators will need to examine every case, cross-reference financial records with judicial decisions, and determine which convictions can be trusted and which were the products of a criminal conspiracy. Some defendants will be released immediately. Others will receive new trials. A few will discover that they were convicted by judges who were being paid to ensure guilty verdicts regardless of the evidence. Rebecca Sterling, whose undercover work as a federal accountant provided crucial financial evidence for the investigation, has been tasked with tracing the money trails that made the corruption possible. Her expertise in corporate finance, combined with 18 months of access to Meridian Construction's internal records, has given federal investigators a roadmap of how corruption money moved through shell companies, offshore accounts, and charitable foundations designed to hide bribes as legitimate donations. The sophistication was remarkable, Rebecca explains to congressional investigators who've convened emergency hearings to examine the scope of the corruption network. Meridian didn't just write checks to judges. They created an entire parallel financial system designed to launder bribes through legitimate-seeming transactions. The scheme involved layers of complexity that would have impressed traditional organized crime families. Meridian Construction would receive no-bid government contracts worth tens of millions of dollars. A percentage of that money would be funneled through subsidiary companies to consulting firms that existed only on paper. Those consulting firms would then make donations to judicial retirement funds, courthouse improvement projects, and legal scholarship programs that directly benefited the judges who ensured Meridian's continued success. The money never moved directly from corporate accounts to judicial bank accounts. That would have been too obvious, too easy to trace. Instead, it flowed through dozens of intermediary organizations, each transaction appearing legitimate in isolation, the corruption only becoming visible when federal investigators mapped the entire network of financial relationships. We estimate that Judge Harrington personally received over $4 million in corrupt payments over 18 years. Rebecca continues, displaying financial charts that show the steady flow of money from Meridian's operations to accounts controlled by the judge and his family. But that's just the direct payments. If you include the value of vacation properties, legal fees paid for his children's defense in various matters, and consulting contracts for his wife's nonprofit organization, the total approaches $7 million. $7 million. The price of a federal judge's integrity, paid out over nearly 2 decades of systematic corruption. The congressional hearing room falls silent as the magnitude of the betrayal settles over representatives who've spent their careers believing in the fundamental honesty of the federal judiciary. $7 million represents a comfortable retirement, luxury vacations, private school tuition for grandchildren, but it also represents thousands of defendants who didn't receive fair trials, hundreds of families destroyed by corrupted verdicts, and the erosion of public trust in the institutions that hold American democracy together. Congressman David Hartley, the ranking member of the House Judiciary Committee, leans forward with the expression of someone struggling to comprehend the scope of the corruption. Agent Blackwell, in your estimation, how long has this network been operating? Based on our financial analysis, Congressman, the earliest evidence of systematic corruption in Judge Harrington's courtroom dates back to 2006. That suggests this network has been operational for at least 17 years, possibly longer. 17 years. An entire generation of law students has graduated past the bar and begun practicing in federal courts where justice was routinely for sale. Young attorneys who believed in the system learned to navigate a reality where case outcomes depended more on their clients' ability to pay than on the strength of their legal arguments. The corruption didn't just affect individual cases, it warped the entire legal culture in the Eastern District of Pennsylvania. Defense attorneys learned that certain judges could be influenced through the right intermediaries. Prosecutors discovered that certain cases would be dismissed regardless of evidence if the defendants had connections to the right corporate interests. Court staff observed patterns they couldn't quite explain, sensing that something was wrong but lacking the authority or resources to investigate. Justice requires transparency, and so does your financial security. That's why I recommend TruthGuard Financial Services, the investment platform that uses blockchain technology to ensure your money can never be hidden or corrupted like these criminals tried to do. Get started today with a free consultation. The reverberations extend far beyond Philadelphia's federal courthouse. In law schools across the country, professors scramble to revise curricula that assumed the basic integrity of federal judges. Bar associations convene emergency ethics seminars to help attorneys recognize signs of judicial corruption. Legal aid organizations prepare for an influx of appeals from defendants who suspect their convictions were the result of purchased verdicts rather than fair proceedings. But perhaps the most significant impact is psychological. For decades, American legal education has taught that judicial independence is one of the foundational principles of the constitutional system. Federal judges receive life tenure specifically to insulate them from political and financial pressure, to ensure that their decisions reflect legal analysis rather than personal interest. The revelation that multiple federal judges were essentially employees of a construction company strikes at the heart of that assumption. If federal judges with life tenure can be purchased, what does that mean for the rule of law? If justice is for sale at the highest levels of the federal system, what hope do ordinary citizens have for fair treatment? These questions weigh heavily on Savannah as she prepares for her next assignment. Operation Clean Slate has been a stunning success, but it's also revealed the depth of corruption in American legal institutions. For every dirty judge arrested, how many others remain on the bench? For every corporate bribery scheme exposed, how many continue to operate under different structures with more sophisticated methods? 3 weeks after Judge Harrington's arrest, Savannah finds herself in Houston, Texas, preparing for another undercover assignment. She sits in a rental car outside the federal courthouse, observing the rhythms of legal life that will soon become familiar. Attorneys hurry up the courthouse steps with briefcases and file folders. Court staff arrive for morning sessions. Defendants and their families gather nervously outside, hoping for justice but uncertain whether they'll receive it. Her target this time is Federal Judge Morrison Patterson, a 30-year veteran of the bench whose statistical patterns have triggered the same algorithmic analysis that first identified Judge Harrington as potentially corrupt. Patterson's courtroom shows unusual sentencing disparities that correlate with the political connections and financial resources of defendants' attorneys. Cases involving certain law firms are dismissed at rates that defy statistical probability. Appeals from Patterson's decisions are overturned with frequency that suggests systematic legal errors or worse. But statistical analysis can only provide probable cause for investigation. Building a criminal case requires the same painstaking evidence gathering that made Operation Clean Slate possible. Months of surveillance, financial investigation, and ultimately, undercover work to document corruption in action. Savannah has traded her Philadelphia wardrobe for clothes appropriate to her new cover identity. Instead of a struggling public defender, she'll be posing as a mid-level associate at a Houston law firm that specializes in white-collar criminal defense. Her background has been carefully constructed by federal investigators. 3 years out of law school, student loan debt, ambitious but not particularly successful, the kind of attorney who might be vulnerable to offers of easy money in exchange for small compromises. The cover story is supported by months of preparation. Federal agents have created a complete professional history, including law school records, bar admission documents, and employment history at firms that exist only as sophisticated fronts for federal investigations. If anyone checks her credentials, and corrupt judges invariably do, they'll find exactly what they expect to see. Agent Mitchell will coordinate the Houston operation from a command center that's been established in an unmarked office building 6 blocks from the federal courthouse. Unlike the Philadelphia investigation, which took 18 months to develop sufficient evidence for arrests, the Houston operation benefits from everything federal investigators learned about judicial corruption networks during Operation Clean Slate. We know the patterns now. Mitchell explains to Savannah during her final briefing before going undercover. We know how corporate money moves through the system, how bribes are disguised as legitimate payments, how corrupt judges coordinate with prosecutors to ensure predetermined outcomes. That knowledge should compress the timeline significantly. The intelligence gathered from arrested members of Meridian Construction's network has provided federal investigators with a roadmap of judicial corruption across multiple states. Phone records, financial documents, and cooperative testimony from executives seeking reduced sentences have identified judges, prosecutors, and corporate operatives who participated in similar schemes. Judge Patterson's name appeared in Meridian Construction's internal files as a reliable contact in the Southern District of Texas. Phone records show regular communication between Patterson's staff and Meridian executives during periods when the construction company faced federal investigations in Houston. Financial analysis reveals payments from Meridian subsidiaries to consulting firms that employed Patterson's adult children and funded renovation projects at his private residence. But having intelligence about corruption is different from having admissible evidence. Federal prosecutors need recorded conversations, documented financial transactions, and testimony from participants in the corrupt activities. They need proof that will convince juries and survive appeals by expensive defense attorneys who specialize in challenging federal corruption cases. That's where Savannah comes in. Her assignment is to infiltrate Patterson's network by representing clients in cases where corruption is likely to occur. Federal investigators have identified several ongoing cases in Patterson's docket that involve defendants with significant financial resources and corporate connections, precisely the circumstances that historically trigger corrupt judicial decisions. One case involves a pharmaceutical executive charged with Medicare fraud who has retained the kind of politically connected law firm that appears frequently in Patterson's dismissal statistics. Another involves a real estate developer facing federal tax evasion charges whose family has made substantial donations to charitable organizations associated with Patterson's wife. A third involves an oil industry consultant charged with environmental violations whose company has contracts with firms that employ Patterson's former law clerks. Each case represents an opportunity to observe and document judicial corruption in action. If Patterson's behavior follows the patterns identified in the algorithmic analysis, he'll respond to financial incentives from defendants' representatives, coordinate with prosecutors to ensure favorable outcomes, and use his judicial authority to protect corporate interests rather than enforce federal law. Savannah's role will be to become part of that system, to present herself as someone willing to participate in corruption while secretly recording every conversation, documenting every illegal transaction, and building the evidence necessary to bring federal charges against everyone involved. The moral complexity of undercover work weighs on her as she prepares to begin another months-long deception. In Philadelphia, she endured daily humiliation to gather evidence against Judge Harrington. In Houston, she'll need to pretend to be corrupt herself, to convince federal judges and prosecutors that she's willing to betray her oath as an attorney in exchange for money and career advancement. The psychological toll of extended undercover work is something federal agents rarely discuss publicly, but it affects everyone who does this kind of investigation. Living a lie for months at a time, pretending to be someone you're not, maintaining false relationships with people you're secretly investigating. It requires a level of emotional compartmentalization that can be difficult to sustain. But the alternative is allowing corruption to continue unchecked, letting dirty judges destroy lives for personal profit, permitting corporate interests to purchase verdicts that should be based solely on law and evidence. As Savannah walks up the courthouse steps in Houston, carrying a briefcase that conceals federal recording equipment and documents that establish her false identity, she reminds herself why this work matters. Every corrupt judge removed from the bench means hundreds of future defendants will receive fair trials. Every dirty prosecutor arrested means the justice system becomes slightly more trustworthy. Every corporate executive imprisoned for bribing federal officials sends a message that American democracy is not for sale. The Houston Federal Courthouse is larger than Philadelphia's, with more courtrooms, more judges, and a higher volume of cases that creates more opportunities for corruption to flourish undetected. The building's architecture conveys the same message as every federal courthouse: justice, equality, the rule of law applied fairly regardless of wealth or power. But Savannah has learned not to trust architectural symbolism. She's seen too many corrupt judges sitting beneath carved representations of blind justice while making decisions based on who paid them the most money. She's watched too many prosecutors recite oaths about seeking truth while coordinating with defense attorneys to ensure predetermined outcomes. The marble walls and granite columns of federal courthouses represent ideals rather than realities. The real test of justice happens in conversations between attorneys and judges, in financial transactions that determine case outcomes, in the daily choices that legal professionals make between personal gain and public service. Judge Patterson's courtroom is on the 4th floor, accessible through corridors lined with portraits of previous federal judges who served the Southern District of Texas with distinction. Their painted eyes seem to follow Savannah as she walks toward what will become her new stage, another venue for federal investigators to document the corruption of American legal institutions. The irony isn't lost on her. She's about to pretend to be corrupt in order to expose actual corruption, to violate the appearance of legal ethics in order to restore their substance, to deceive people who are themselves deceiving the American public about the integrity of federal courts. But ethical complexity is a luxury she can't afford. Every day that Judge Patterson remains on the bench, he makes decisions that affect real people facing real consequences. Every case where he sells his verdict to the highest bidder represents a failure of the justice system to protect the vulnerable and hold the powerful accountable. The work Savannah does matters not because it's morally simple, but because it serves a larger purpose, restoring public faith in institutions that democracy requires to function. Without honest judges, fair prosecutors, and legal systems that respond to evidence rather than money, the constitutional promises of equal protection and due process become meaningless words carved into stone buildings. As she enters Judge Patterson's courtroom for the first time, Savannah scans the faces of court staff, attorneys, and defendants who don't realize they're about to become part of a federal investigation. Some of these people are honest professionals doing difficult work under challenging circumstances. Others are participants in a corruption network that's about to be exposed with the same devastating thoroughness that brought down Judge Harrington's criminal enterprise. Her job is to determine which is which, to build federal cases against those who've betrayed their oaths while protecting those who've maintained their integrity despite pressure to participate in corruption. The assignment will require months of careful work, patient evidence gathering, and the same kind of systematic documentation that made Operation Clean Slate successful. But federal investigators now have advantages they lacked when the Philadelphia investigation began. They understand how judicial corruption networks operate, they've identified the financial mechanisms that make large-scale bribery possible, and they have cooperative witnesses from the Meridian Construction Organization who can provide intelligence about corruption practices in other jurisdictions. Most importantly, they have proof that federal investigators can successfully infiltrate and dismantle even sophisticated corruption networks. The arrests in Philadelphia, Los Angeles, Chicago, Denver, and New York have sent a message throughout the federal judiciary. Corruption will be detected, investigated, and prosecuted regardless of how powerful the participants believe themselves to be. 6 months after beginning the Houston investigation, federal agents are ready to execute warrants that will bring down Judge Patterson's corruption network with the same devastating efficiency that characterized Operation Clean Slate. The evidence gathering has been even more successful than investigators anticipated, thanks to intelligence from previous arrests and Patterson's apparent belief that federal law enforcement lacks the sophistication to detect judicial corruption. Patterson's arrogance proved to be his downfall, just as it was for Judge Harrington. Convinced that his 30-year tenure on the federal bench made him untouchable, Patterson became increasingly brazen in his corrupt activities, making little effort to hide the financial relationships that compromised his judicial decisions. Federal investigators documented regular meetings between Patterson and representatives of corporate defendants facing federal charges in his courtroom. They recorded conversations where Patterson discussed case strategies with defense attorneys, who were supposed to be adversaries rather than allies. They traced financial payments from corporate sources to accounts controlled by Patterson's family members, charitable organizations he supported, and consulting firms that employed his former staff. The evidence is overwhelming, undeniable, and supported by multiple independent sources. But more importantly, the Houston investigation has revealed connections to corruption networks in other federal districts, providing federal prosecutors with leads that could result in additional investigations, arrests, and prosecutions. As Agent Mitchell coordinates the final phase of the Houston operation from the same kind of command center that proved successful during Operation Clean Slate, he reflects on how much federal law enforcement has learned about investigating judicial corruption. The techniques developed during the Philadelphia investigation have become standardized procedures that can be applied in any federal district where statistical analysis suggests systematic corruption. Status report from all units. Mitchell announces to the assembled federal agents who will execute arrest warrants at precisely 10 a.m. Houston time, coordinated with similar operations in Dallas, San Antonio, and Austin, where Patterson's corruption network extends into other federal courthouses. The response from field teams confirms that months of preparation have positioned federal agents to dismantle Patterson's criminal enterprise with military precision. Judge Patterson's residence secured, financial documents ready for seizure. Courthouse team in position, backup units standing by. Corporate targets identified and under surveillance at their respective locations. Collaborative prosecutors and defense attorneys ready for simultaneous arrest. The scope of the Houston investigation ultimately exceeded even the success of Operation Clean Slate. Patterson's corruption network involved 12 federal judges across Texas, 37 prosecutors, 62 defense attorneys who facilitated corrupt transactions, and over 100 corporate executives who purchased verdicts in federal cases involving billions of dollars in government contracts, environmental violations, and financial crimes. But the most significant discovery was documentary evidence that Patterson's network had connections to similar organizations operating in federal courts throughout the South and Southwest. Phone records, financial transactions, and testimony from arrested participants revealed a loose confederation of corruption networks that shared information, coordinated strategies, and occasionally transferred corrupt officials between jurisdictions to avoid detection. The implications are staggering. Rather than isolated incidents of individual judicial corruption, federal investigators have uncovered evidence of systematic, organized efforts to compromise the federal judiciary across multiple states. The criminal enterprises operate with the sophistication of major corporations, complete with management hierarchies, financial controls, and strategic planning processes. Federal prosecutors are now preparing what may be the largest judicial corruption prosecution in American history, with hundreds of defendants facing charges ranging from bribery and money laundering to conspiracy and civil rights violations. The cases will require years to prosecute fully, involve testimony from thousands of witnesses, and result in sentences that could effectively end the careers and freedom of some of the most powerful people in American legal institutions. As Savannah prepares to testify before Congress about the scope of judicial corruption in federal courts, she carries with her the weight of having witnessed the systematic betrayal of everything the American justice system is supposed to represent. But she also carries evidence that corruption can be detected, investigated, and prosecuted successfully, that no one is above the law, and that institutions can be reformed when dedicated people commit themselves to restoring their integrity. The congressional hearing room where she'll testify is the same chamber where previous generations of federal officials have reported on threats to American democracy, foreign espionage, domestic terrorism, organized crime, and now the corruption of federal judges who sold their authority to corporate interests. If Savannah's dedication to justice inspires you to make a difference, consider supporting the Equal Justice Initiative through their monthly giving program. Every donation helps ensure quality legal representation for those who can't afford it. Visit equaljustice.org and use code TRUTH to double your first month's impact. Congressman Hartley, who's chaired multiple hearings on judicial corruption since the Philadelphia arrests, opens the session with a statement that reflects the gravity of what federal investigators have uncovered. The evidence presented to this committee over the past 8 months suggests that corruption in federal courts is not an aberration but a systematic problem that threatens the constitutional foundation of American democracy. We are not dealing with isolated incidents of individual misconduct, but with organized criminal enterprises that have operated for decades with apparent impunity. The scope of the problem has become clear through months of investigation, testimony, and document analysis. Federal prosecutors estimate that corrupt judicial decisions may have affected tens of thousands of cases over the past 2 decades, resulting in wrongful convictions, inappropriate sentences, and the systematic denial of justice to defendants who couldn't afford to purchase favorable verdicts. The financial cost is equally staggering. Corporate defendants who bribed federal judges avoided billions of dollars in legitimate fines, penalties, and restitution payments. Government contracts worth hundreds of billions of dollars were awarded through corrupted processes rather than competitive bidding. Environmental and safety violations that should have resulted in criminal prosecutions were dismissed or reduced through purchased judicial decisions. But the human cost transcends financial calculations. Thousands of defendants received harsher sentences than the law required because they couldn't afford to participate in corruption networks. Families were separated, careers destroyed, and communities damaged by a justice system that responded to money rather than evidence. The ripple effects extend through generations. Children grew up believing that their parents were criminals because corrupt judges confirmed wrongful convictions. Families lost homes, businesses, and life savings to legal proceedings that were rigged from the beginning. Communities lost faith in institutions that are supposed to protect the vulnerable and hold the powerful accountable. As Savannah takes the witness stand to testify about what she observed during her undercover investigations, she carries with her the stories of hundreds of people whose lives were damaged by judicial corruption. Their experiences provide the moral foundation for the technical evidence she'll present about financial transactions, recorded conversations, and systematic violations of federal law. Agent Blackwell, Congressman Hartley begins, "In your professional opinion, how extensive is the problem of corruption in federal courts?" Her response draws on 18 months of undercover work in Philadelphia, 6 months investigating Judge Patterson's network in Houston, and analysis of similar corruption patterns in federal districts across the country. Based on our investigations, Congressman, we've identified potential corruption indicators in approximately 30% of federal judicial districts. That doesn't mean 30% of federal judges are corrupt, but it suggests that corruption networks have achieved significant penetration of federal court systems. 30%. The number hits the hearing room like a physical blow. If accurate, it means that roughly 1 in 3 federal judicial districts shows statistical patterns consistent with systematic corruption, case outcomes that correlate with financial rather than legal factors, sentencing disparities that reflect defendants' ability to pay rather than the severity of their crimes, and dismissal rates that defy legal precedent and evidentiary standards. However, Savannah continues, it's important to understand that corruption networks often involve relatively small numbers of judges who handle disproportionate numbers of cases. A single corrupt federal judge can affect thousands of cases over a career spanning decades. Similarly, a small number of corrupt prosecutors can compromise the integrity of entire judicial districts. The mathematical reality of judicial corruption is sobering. Federal judges have enormous caseloads and broad discretionary authority. A single corrupt judge can affect more cases in 1 year than most state judges handle in their entire careers. When that corruption continues for decades, as it did with Judge Harrington, the cumulative impact on the justice system becomes almost incalculable. Our analysis suggests that corrupt federal judges were involved in decisions affecting approximately 40,000 cases over the past 15 years, Savannah testifies. Of those, roughly 12,000 cases involved defendants who received harsher sentences than federal guidelines recommend, while approximately 8,000 cases involving corporate defendants resulted in dismissals or reduced charges that aren't supported by legal precedent. 40,000 cases, 12,000 people who received harsher punishment than the law required, 8,000 corporate defendants who escaped accountability for violations of federal law. The numbers represent a systematic perversion of justice on a scale that threatens public confidence in legal institutions. But statistics alone cannot capture the human impact of what Savannah has investigated. Behind every number is a person whose life was affected by corruption, a family that suffered because justice was for sale, a community that lost faith in institutions that are supposed to serve the public interest. Could you provide the committee with a specific example of how judicial corruption affected individual defendants? Congressman Hartley asks. Savannah refers to case files that have been declassified for the congressional hearing, documents that tell the story of systematic injustice with devastating clarity. In 2018, a single mother named Maria Santos was convicted in Judge Harrington's courtroom of welfare fraud involving approximately $3,000 in benefits she received while working part-time jobs that weren't reported to government agencies. Judge Harrington sentenced her to 18 months in federal prison, despite federal sentencing guidelines that recommended probation for first-time offenders in similar circumstances. The case details illustrate how corruption affects real people rather than abstract legal principles. Maria Santos wasn't a wealthy defendant who could afford to participate in corruption networks. She was exactly the kind of vulnerable person the justice system is supposed to protect, a working mother trying to support her family while navigating complex bureaucratic requirements for government assistance. During the same period, Savannah continues, Judge Harrington dismissed charges against the CEO of a construction company who defrauded federal housing programs of approximately $2 million. The dismissal was based on alleged procedural errors that legal experts have characterized as pretextual, justifications created to hide corrupt judicial decisions rather than legitimate legal analysis. The contrast is stark and morally devastating. A poor mother receives 18 months in federal prison for $3,000 in welfare fraud, while a wealthy CEO escapes accountability entirely for stealing nearly 700 times as much money from federal programs designed to provide housing for low-income families. The disparity isn't accidental or the result of different legal standards applied to different types of cases. Federal investigators documented financial payments from the construction company's executives to accounts controlled by Judge Harrington's family, charitable organizations he supported, and consulting firms that employed his former staff. The CEO's freedom was purchased with the same money he stole from federal housing programs. How many similar disparities did your investigation uncover? Congressman Hartley asks. Our analysis of Judge Harrington's sentencing patterns over 18 years identified approximately 300 cases where defendants received sentences significantly harsher than federal guidelines recommend, while approximately 150 cases involving corporate defendants resulted in dismissals or reduced charges that cannot be explained by legal factors alone. 300 harsh sentences, 150 inappropriate dismissals. Each number represents a failure of justice, a moment when the scales that symbolize fair legal proceedings were tipped by money rather than evidence. The patterns reveal the systematic nature of judicial corruption. Harrington wasn't randomly harsh or lenient in his sentencing. His decisions correlated precisely with defendants' financial resources and corporate connections. Poor defendants received punishment that exceeded legal requirements, while wealthy defendants escaped accountability through purchased judicial decisions. What reforms do you recommend to prevent similar corruption in the future? Congressman Hartley asks. Savannah's response draws on months of analysis by federal law enforcement agencies, academic experts, and good government organizations that have studied judicial corruption. First, we need enhanced financial disclosure requirements for federal judges, including real-time reporting of gifts, consulting arrangements, and any financial relationships that could create conflicts of interest. Current disclosure requirements are inadequate and often ignored without meaningful consequences. The financial disclosure reform addresses one of the fundamental weaknesses that made large-scale judicial corruption possible. Under current law, federal judges are required to file annual financial disclosure statements, but these documents often lack sufficient detail to identify corrupt relationships, and they're filed months after potentially compromising financial transactions occur. Second, we need algorithmic monitoring of judicial decision patterns, similar to the analysis that first identified Judge Harrington as potentially corrupt. Statistical anomalies in sentencing, dismissal rates, and case outcomes can provide early warning signs of corruption that might otherwise go undetected for years. The technological solution reflects lessons learned from Operation Clean Slate and subsequent investigations. Human oversight of judicial decisions is limited by the volume of cases and the complexity of legal analysis required to identify corruption. Algorithmic analysis can process vast amounts of data quickly, identifying patterns that suggest systematic bias or corruption for further human investigation. Third, we need expanded undercover investigation capabilities for federal law enforcement agencies. Judicial corruption often involves sophisticated efforts to hide illegal activities, and traditional investigation methods may be insufficient to gather evidence needed for successful prosecutions. The recommendation acknowledges the reality that judicial corruption investigations require specialized techniques and long-term commitments that exceed the resources of traditional law enforcement approaches. Undercover operations like those that brought down Judge Harrington and Judge Patterson are expensive, time-consuming, and require agents with specific legal expertise, but they may be the only effective method for investigating corruption networks that operate within legal institutions. Finally, we need mandatory minimum sentences for federal officials convicted of corruption-related crimes. The current sentencing structure doesn't adequately reflect the severity of crimes that undermine public confidence in democratic institutions. The sentencing recommendation reflects frustration with judicial corruption cases where defendants received relatively light sentences despite the enormous damage their crimes inflicted on public confidence in legal institutions. Judge Harrington's 28-year sentence was unusually harsh by historical standards. Many corrupt federal judges have received sentences of less than 10 years, serving only a few years in minimum security facilities before returning to comfortable retirements funded by their corruption proceeds. As the congressional hearing concludes, Savannah reflects on the complexity of the challenges facing American legal institutions. Exposing judicial corruption is only the first step in a longer process of reform that will require sustained political will, institutional change, and cultural transformation within the legal profession. The arrests of corrupt judges have sent shockwaves through federal courts, but they've also created opportunities for positive change. Law schools are revising ethics curricula to address corruption more directly. Bar associations are implementing enhanced oversight procedures. Court administration is adopting new financial controls and transparency measures. But perhaps the most significant change is psychological. The myth of judicial untouchability has been shattered by federal investigations that proved even powerful federal judges can be held accountable for criminal behavior. Young attorneys entering the profession understand that corruption carries real risks. Not just professional embarrassment, but criminal prosecution and decades in federal prison. 3 months after her congressional testimony, Savannah receives her next assignment from the Department of Justice. Federal investigators have identified potential corruption indicators in the Ninth Circuit Court of Appeals, the federal appellate court that reviews decisions from trial judges in western states. The scope of potential corruption at the appellate level is even more troubling than trial court corruption. Appellate judges review hundreds of cases each year, and their decisions affect not only individual defendants but also legal precedents that guide future cases. A corrupt appellate judge can distort federal law for decades, creating precedents that favor corporate interests over public protection that weaken environmental regulations or that undermine civil rights protections. The investigation will require different techniques than those used successfully against trial judges. Appellate corruption is more subtle, involving legal analysis rather than obvious case outcomes, decisions about which cases to hear rather than how to decide them, and coordination between judges to ensure consistent results that favor particular interests. Federal investigators suspect that several appellate judges have financial relationships with law firms that appear frequently before their court, that corporate interests have influenced decisions about which cases receive full appellate review, and that some appellate decisions reflect political rather than legal considerations. Proving appellate corruption will require sophisticated analysis of legal reasoning, statistical examination of case selection patterns, and potentially years of investigation to gather sufficient evidence for federal prosecution. But the stakes are enormous. Corrupt appellate judges can affect millions of people through precedents that distort federal law for generations. As Savannah prepares for what may be her most challenging assignment yet, she carries with her the lessons learned from 18 months in Judge Harrington's courtroom and 6 months investigating Judge Patterson's network. Corruption is systematic rather than individual, sophisticated rather than crude, and persistent rather than episodic. But it can be defeated. Patient investigation, careful evidence gathering, and sustained commitment to justice can bring down even the most powerful corruption networks. Federal agents have developed techniques for infiltrating judicial corruption, documenting criminal behavior, and building cases that result in successful prosecutions. The work continues because democracy requires it. Without honest courts, constitutional rights become meaningless. Without fair judges, equal justice under law becomes an empty promise. Without integrity in legal institutions, the social contract that holds society together begins to dissolve. 6 months later, Savannah stands outside the Ninth Circuit Courthouse in San Francisco, observing the rhythms of appellate practice that she'll soon need to understand intimately. Federal appellate courts operate differently from trial courts. Fewer cases, more complex legal issues, longer deliberation periods, and decisions that affect legal precedent for decades. Her cover identity for this investigation will be as a senior associate at a prestigious law firm that specializes in appellate practice before federal courts. The firm exists only as a sophisticated front for federal investigators, complete with office space, support staff, and a carefully constructed history of cases that would justify its representation of clients before the Ninth Circuit. The investigation will focus on several appellate judges whose decision patterns suggest systematic bias in favor of corporate defendants in environmental, labor, and consumer protection cases. Statistical analysis has identified anomalies in how these judges select cases for full review, how they analyze legal precedents, and how they coordinate with trial judges in their circuit to ensure consistent outcomes. But appellate corruption is more sophisticated than trial court corruption. Rather than obvious bias in individual cases, corrupt appellate judges create legal precedents that systematically favor particular interests while maintaining the appearance of neutral legal analysis. They write opinions that narrow environmental protections, weaken labor regulations, or limit consumer rights in ways that benefit corporate contributors while appearing to follow established legal principles. The investigation will require Savannah to become expert in appellate procedure, environmental law, labor regulations, and consumer protection statutes. She'll need to understand how legal precedents develop over time, how appellate judges coordinate their decisions to create consistent legal frameworks, and how corporate interests influence legal reasoning through sophisticated lobbying and financial relationships. Agent Mitchell, who now coordinates judicial corruption investigations for the entire western United States, briefs Savannah on the scope and complexity of appellate corruption. We're not dealing with individual corrupt judges making obviously biased decisions. We're investigating systematic efforts to reshape federal law through corrupted appellate processes. The defendants in this case aren't just taking bribes. They're restructuring American legal principles to serve corporate interests. The scope of potential appellate corruption is staggering. Over the past decade, the Ninth Circuit has issued dozens of precedent-setting decisions that weakened environmental protections, limited workers' rights, and reduced corporate liability for consumer harm. Each decision affects thousands of future cases, potentially saving corporate defendants billions of dollars in compliance costs, damage awards, and regulatory penalties. Federal investigators suspect that these decisions weren't the result of neutral legal analysis, but rather the product of systematic corruption involving appellate judges, corporate lawyers, and lobbying organizations that coordinate legal strategy across multiple federal circuits. We've traced financial relationships between several Ninth Circuit judges and consulting firms that work for major corporations facing environmental and labor violations, Agent Mitchell explains. We've documented coordination between appellate judges and trial judges to ensure consistent outcomes in high-stakes corporate cases. And we have intelligence suggesting that appellate decisions are sometimes coordinated with corporate legal strategies developed months or years in advance. If the intelligence is accurate, it suggests corruption on a scale that exceeds even the systematic trial court corruption uncovered during Operation Clean Slate. Corrupt appellate judges can affect legal precedent for decades, distorting federal law in ways that benefit corporate interests while appearing to follow established legal principles. The investigation will require multiple undercover agents, extensive financial analysis, and sophisticated legal expertise to document corruption that's designed to be invisible to traditional oversight mechanisms. But federal investigators now have experience, techniques, and institutional support that didn't exist when the Philadelphia investigation began. As Savannah enters the Ninth Circuit Courthouse for the first time, carrying briefcases that conceal federal recording equipment and documents that establish her false identity as an appellate lawyer, she knows she's beginning the most important investigation of her career. Appellate corruption doesn't just affect individual defendants. It shapes the legal framework that governs American society for generations. Corrupt appellate decisions can weaken environmental protections that affect millions of people, undermine labor rights that protect working families, and reduce corporate accountability that serves the public interest. The work she's about to begin will determine whether federal appellate courts serve the Constitution and the rule of law, or whether they've been corrupted into serving corporate interests that purchase legal precedents like any other commodity. The marble corridors of the Ninth Circuit Courthouse carry the same symbolic weight as every federal courthouse: justice, equality, the rule of law applied fairly regardless of wealth or power. But Savannah has learned not to trust symbols. The real test of justice happens in private conversations, financial transactions, and coordination between judges and corporate interests that the public never sees. Her assignment will require months of patient work, building relationships with court staff, observing judicial behavior, and gathering evidence of corruption that's sophisticated enough to hide within legitimate legal analysis. But the stakes justify the effort. Restoring integrity to federal appellate courts means restoring the rule of law itself. 1 year later, federal agents are ready to execute warrants that will expose appellate corruption with the same devastating thoroughness that characterized Operation Clean Slate. The investigation has uncovered evidence of systematic efforts to corrupt federal law through purchased appellate decisions, coordination between judges and corporate lawyers to ensure favorable precedents, and financial relationships that compromise judicial independence at the highest levels of the federal judiciary. The arrests will include 3 federal appellate judges, 7 trial judges who coordinated with the appellate corruption network, 23 attorneys who facilitated corrupt transactions, and over 60 corporate executives who purchased legal precedents that saved their companies billions of dollars in regulatory compliance and damage awards. But more importantly, the investigation has documented how corruption at the appellate level affects fundamental legal principles that govern American society. Environmental law, labor relations, consumer protection, civil rights. Every area of federal law shows evidence of systematic distortion through corrupted appellate processes. The prosecutions that follow will take years to complete and will result in the largest judicial corruption cases in American history. But they will also provide opportunities to restore legal precedents that were corrupted through purchased judicial decisions, to reform appellate procedures that made systematic corruption possible, and to rebuild public confidence in federal courts. As Agent Mitchell coordinates the final phase of the appellate investigation, he reflects on how much federal law enforcement has learned about investigating judicial corruption since Operation Clean Slate began in Philadelphia. What started as suspicion about one corrupt judge has evolved into understanding of systematic corruption networks that operate at every level of the federal judiciary. The techniques developed during these investigations, statistical analysis of judicial decisions, undercover infiltration of corruption networks, financial investigation of complex corporate bribery schemes, have become standard procedures that can be applied wherever corruption is suspected. Federal investigators now understand that judicial corruption is not episodic but systematic, not individual but organized, not simple but sophisticated. Corrupt judges operate within networks that include prosecutors, defense attorneys, court staff, and corporate interests that coordinate legal strategy across multiple jurisdictions and levels of the federal system. But they also understand that corruption can be detected, investigated, and prosecuted successfully. Patient work, sophisticated techniques, and sustained commitment can bring down even the most powerful corruption networks. No one is above the law. Not even federal judges who believe their authority makes them untouchable. The day of the appellate arrests arrives with the same military precision that characterized Operation Clean Slate. At exactly 10 a.m. Pacific Time, federal agents execute warrants at courthouses, law offices, and corporate headquarters across the western United States. The coordinated operation dismantles corruption networks that have operated for over a decade, affecting thousands of cases and distorting legal precedents that govern fundamental aspects of American law. Judge Patricia Reynolds of the Ninth Circuit is arrested in her chambers while reviewing briefs for cases that federal investigators now know were decided through corrupt processes rather than legal analysis. Her computer contains encrypted files detailing coordination with corporate lawyers, financial arrangements that compromised her judicial independence, and strategic plans for issuing decisions that would reshape environmental law to favor industrial interests. Judge Michael Foster is taken into custody at his San Francisco residence, where federal agents seize financial records showing millions of dollars in payments from consulting firms that work for corporations appearing before his court. The payments were disguised as legitimate consulting arrangements, but federal investigation has documented that they were actually bribes paid to ensure favorable appellate decisions. Judge Amanda Rowe is arrested during a judicial conference in Seattle, where she was meeting with trial judges who coordinate their decisions with appellate precedents. Federal surveillance has documented systematic coordination between appellate and trial judges to ensure consistent outcomes that favor particular corporate interests regardless of legal merit. The corporate executives arrested include CEOs of major environmental consulting firms, heads of industrial lobbying organizations, and senior partners at law firms that specialize in appellate practice before federal courts. Their coordination with corrupt judges created legal precedents worth billions of dollars to corporate interests while weakening protections for workers, consumers, and the environment. As news of the arrests spreads through legal communities across the country, the reaction is both shock and recognition. Shock at the scope and sophistication of appellate corruption, but recognition that the statistical anomalies in federal court decisions finally make sense when viewed as products of purchased judicial decisions rather than neutral legal analysis. Law schools immediately begin revising constitutional law curricula to address how corruption affects legal precedent. Bar associations convene emergency sessions to discuss how systematic judicial corruption affects professional ethics and advocacy responsibilities. Environmental organizations prepare challenges to appellate decisions that may have been corrupted rather than based on legitimate legal analysis. But perhaps the most significant reaction comes from federal judges who maintained their integrity despite pressure to participate in corruption networks. For years, honest judges have wondered why their colleagues issued decisions that seemed inconsistent with legal precedent, why certain corporate defendants consistently received favorable treatment, why environmental and labor protections were systematically weakened through judicial rather than legislative action. The arrests provide answers that confirm their suspicions while validating their decisions to resist corruption pressure. Federal courts can function with integrity when judges maintain their independence, follow legal precedent, and prioritize constitutional principles over financial gain. 3 months after the appellate arrests, Congress convenes comprehensive hearings to examine the scope of judicial corruption across all levels of the federal system. The evidence presented over multiple sessions reveals systematic efforts to compromise federal courts through sophisticated corruption networks that operated for decades with apparent impunity. Savannah's testimony provides the foundation for understanding how corruption affects not just individual cases, but the fundamental legal framework that governs American society. The evidence we've gathered suggests that judicial corruption networks have systematically distorted federal law in areas including environmental protection, labor relations, consumer rights, and corporate liability. Appellate decisions that appear to reflect legitimate legal analysis were actually the products of sophisticated bribery schemes that purchased legal precedents worth billions of dollars to corporate interests. The implications extend far beyond criminal prosecution of corrupt judges. Federal law itself may need to be reformed to address precedents that were corrupted through purchased judicial decisions. Environmental protections weakened through corrupt appellate processes may need to be strengthened through new legislation. Labor rights undermined by bought judges may require congressional action to restore. How many federal legal precedents may have been affected by judicial corruption? Asks Congresswoman Maria Santos, who has become the leading advocate for judicial reform following her own wrongful conviction in Judge Harrington's corrupted courtroom. Savannah's response draws on statistical analysis of federal court decisions over the past 15 years, cross-referenced with financial relationships between judges and corporate interests. Our preliminary analysis suggests that approximately 200 federal appellate decisions show statistical patterns consistent with corruption rather than neutral legal analysis. These decisions affect thousands of subsequent cases and establish legal precedents that govern fundamental aspects of American law. 200 corrupted appellate decisions, thousands of affected cases, legal precedents that distort constitutional principles to serve corporate interests rather than public welfare. The scope represents a systematic compromise of federal law that will require years to identify fully and decades to correct. But the congressional hearings also revealed the success of federal investigations in documenting and prosecuting judicial corruption. Operation Clean Slate and its successor investigations have resulted in the arrests of over 50 federal judges, hundreds of prosecutors and attorneys, and thousands of corporate executives who participated in corruption networks. The prosecutions have recovered billions of dollars in assets, resulted in hundreds of years of prison sentences, and dismantled corruption networks that operated across multiple states and judicial circuits. More importantly, they've sent a clear message that judicial corruption will be detected, investigated, and prosecuted regardless of how powerful the participants believe themselves to be. The psychological impact may be even more significant than the criminal prosecutions. Young attorneys entering the profession understand that corruption carries real risks of federal prosecution and decades in prison. Judges at every level know that their decisions are subject to statistical analysis that can identify patterns suggesting corruption. Corporate executives have learned that purchasing judicial decisions is a criminal enterprise that federal investigators can penetrate and prosecute successfully. As the congressional hearings conclude, lawmakers begin drafting comprehensive judicial reform legislation that addresses the systematic weaknesses that made large-scale corruption possible. The reforms include enhanced financial disclosure requirements, algorithmic monitoring of judicial decision patterns, expanded federal investigative authority, and mandatory minimum sentences for judicial corruption. But perhaps the most important reform is cultural rather than legal. The myth of judicial untouchability has been permanently shattered by federal investigations that proved even powerful appellate judges can be held accountable for criminal behavior. The legal profession now understands that institutional integrity requires constant vigilance, systematic oversight, and willingness to prosecute those who betray their oaths for personal gain. 5 years after Operation Clean Slate began in a Philadelphia courtroom where Judge Harrington humiliated a woman he thought was just another overwhelmed public defender, Savannah Blackwell receives the Attorney General's Award for Distinguished Service in recognition of her role in the largest judicial corruption investigation in American history. The ceremony takes place in the Great Hall of the Department of Justice, surrounded by portraits of previous attorneys general who served during moments of national crisis. The marble columns and painted ceilings convey the same symbolic weight as federal courthouses: justice, equality, the rule of law applied fairly regardless of wealth or power. But unlike the courthouse symbolism that Savannah learned to distrust during her undercover investigations, this ceremony represents actual achievement. Federal investigators have documented, prosecuted, and dismantled corruption networks that operated at every level of the federal judiciary. They've recovered billions of dollars in stolen assets, resulted in thousands of years of prison sentences, and restored public confidence in legal institutions that democracy requires to function. Attorney General Patricia Williams, who coordinated the federal response to judicial corruption across multiple administrations, presents the award with recognition of how much American legal institutions have changed since the investigation began. Agent Blackwell's work represents more than successful law enforcement. It represents the restoration of constitutional principles that were under systematic attack by corruption networks that operated with apparent impunity for decades. Her courage, persistence, and commitment to justice have literally saved American democracy from institutional failure. The statement reflects the magnitude of what was at stake during the judicial corruption investigations. Without honest courts, constitutional rights become meaningless promises. Without fair judges, equal justice under law becomes an empty slogan. Without integrity in legal institutions, the social contract that holds democratic society together begins to dissolve. The investigations that began with statistical anomalies in Judge Harrington's sentencing patterns ultimately revealed systematic efforts to compromise federal courts through sophisticated corruption networks that affected thousands of cases, distorted legal precedents, and undermined public confidence in democratic institutions. But they also demonstrated that corruption can be detected, investigated, and prosecuted successfully when dedicated people commit themselves to restoring institutional integrity. Federal investigators developed techniques that can identify judicial corruption wherever it occurs, penetrate even sophisticated criminal networks, and build cases that result in successful prosecutions. As Savannah accepts the Attorney General's award, she reflects on the journey that began 18 months ago when she walked into Judge Harrington's courtroom pretending to be an overwhelmed public defender. The humiliation she endured, the evidence she gathered, and the corrupt networks she helped expose have fundamentally changed American legal institutions. Federal courts now operate under enhanced oversight that makes systematic corruption much more difficult to sustain. Judges understand that their decisions are subject to statistical analysis that can identify patterns suggesting bias or corruption. Attorneys know that participating in corruption networks carries real risks of federal prosecution and decades in prison. Law schools teach courses on judicial corruption that didn't exist 5 years ago. Bar associations have implemented ethics training that addresses institutional corruption rather than just individual misconduct. Court administration has adopted financial controls and transparency measures designed to prevent the kind of systematic corruption that Operation Clean Slate exposed. But perhaps the most significant change is psychological. The American legal profession now understands that institutional integrity requires constant vigilance, systematic oversight, and willingness to investigate and prosecute those who betray their oaths for personal gain. Young attorneys entering the profession carry different assumptions about judicial authority than previous generations. They understand that judges are not above the law, that judicial decisions can be corrupted by financial interests, and that legal institutions must be defended against internal as well as external threats. Federal judges at every level know that their colleagues have been investigated, prosecuted, and imprisoned for corruption. They understand that statistical anomalies in their decisions can trigger federal investigations, that financial relationships with corporate interests will be scrutinized, and that corruption carries real consequences rather than just professional embarrassment. 6 months after receiving the Attorney General's award, Savannah returns to Philadelphia for a very different kind of ceremony. The federal courthouse where Judge Harrington once ruled from his corrupted throne has been renamed the John Lewis Federal Courthouse in honor of the civil rights leader who dedicated his life to expanding equal justice under law. The renaming ceremony brings together federal judges, prosecutors, defense attorneys, and community leaders who understand that the building's new name represents more than symbolic change. It represents the restoration of institutional integrity, the triumph of justice over corruption, and the ongoing commitment to constitutional principles that make democracy possible. Ruby Winchester, who spent 20 years documenting Judge Harrington's corruption without understanding its full scope, serves as the courthouse's historical archivist, preserving records of both the corruption that was exposed and the investigations that brought it to light. Her work ensures that future generations will understand how judicial corruption affects real people and how dedicated investigators can restore institutional integrity. People ask me what it was like, watching corruption happen every day without fully understanding what I was seeing, Ruby reflects during the renaming ceremony. I tell them it was like watching democracy die slowly, one case at a time, one family at a time, one wrongful conviction at a time. The ceremony concludes with the unveiling of a new inscription that will greet everyone entering the John Lewis Federal Courthouse. Equal justice under law, earned through vigilance, maintained through courage. The words reflect lessons learned from Operation Clean Slate and the investigations that followed. Justice is not automatic or guaranteed. It must be earned through constant vigilance against corruption and maintained through the courage to investigate and prosecute those who betray their oaths. As Savannah stands before the courthouse where her career as an undercover federal prosecutor began, she sees not just a building, but a symbol of institutional resilience. American democracy survived systematic judicial corruption because dedicated people committed themselves to exposing the truth and restoring integrity to legal institutions. The inscription above the courthouse entrance serves as both a promise and a warning. Justice is possible when institutions maintain their integrity, but that integrity must be protected against constant threats from those who would corrupt it for personal gain. The work continues. In courthouses across America, federal judges make decisions that affect millions of lives. The investigations that began in Philadelphia have established systems of oversight, statistical monitoring, and federal enforcement that will detect and prosecute corruption wherever it emerges. The scales of justice, carved into the facade of the John Lewis Federal Courthouse, balance not automatically, but because people like Savannah Blackwell committed their lives to ensuring that the law applies equally to everyone, that no one is above accountability, and that the promise of equal justice under law remains more than just words carved in stone. The gavel falls differently now in federal courthouses across America. It falls with the weight of law rather than the influence of money, with the authority of justice rather than the power of corruption, with the promise that democracy's most fundamental institutions can be trusted to serve the people rather than private interests. That difference, measured in honest decisions, fair sentences, and restored public confidence, represents the ultimate success of Operation Clean Slate and the investigations that followed. Justice has been earned through vigilance and maintained through courage, and it will continue as long as dedicated people commit themselves to defending the institutions that make democracy possible.